If you've spent any time in the darker corners of the family court internet, you've likely heard the name Tina Swithin. She has built a significant online presence as a self-styled advocate for protective parents, a warrior against what she calls the family court crisis. One mom's battle, her platform, and its offshoots have become a digital rallying point for parents, mostly mothers, who believe the system is failing their children. She speaks with absolute certainty. She presents stories of abuse and injustice, and recently she announced a pause. She is stepping back from her public platforms. She cites harassment and threats as the reason, which are never acceptable. No one should face genuine threats for their work. But here's the thing. When someone who built a brand on aggressive, public confrontation suddenly goes quiet, it's natural to ask, is that the whole story? It's like a bald eagle suddenly saying it's giving up flying to focus on the ground. You'd have questions. Pulling on a few public threads reveals something more complicated than a simple retreat from trolls. Public records, court filings, critical reports from legal professionals. Let's talk about the elephant in the room, or, more accurately, the $1 million lawsuit in the federal courthouse. In August 2025, Christopher Ambrose filed a comprehensive defamation lawsuit against Tina Swithin in Connecticut. He wasn't asking for an apology. He was asking for $1 million in damages. The lawsuit document is in public records, a masterclass in organized grievance. It alleges defamation. It alleges false light invasion of privacy. It alleges intentional infliction of emotional distress. This is not your average angry email. This is the legal equivalent of bringing a bazooka to a knife fight. According to the complaint, Swithin repeatedly and publicly accused Ambrose of heinous acts against his children: sexual abuse, emotional abuse, physical abuse. These are life-destroying accusations. But here's the kicker. The lawsuit alleges she continued, despite overwhelming contrary evidence. The complaint details multiple court findings, hospital evaluations, investigations by the Department of Children and Families. All concluded the allegations were unfounded. They found no evidence of abuse, zero. And yet, the accusations allegedly kept coming from Swithin's platforms. The lawsuit calls this a willful disregard of evidence. Think about that for a second. Ambrose's lawyers sent cease and desist documentation. It included exculpatory evidence from official investigations. Here is the proof your claims are false. Please stop. Her reported response was not a retraction. It was an escalation. If proven true in court, it paints a troubling picture. An advocate committed to her narrative, ignoring exonerating findings. Courts, Child Protective Services. It suggests a dangerous certainty divorced from verifiable facts. This lawsuit is a critical piece of the puzzle, not an angry blog post, a formal legal challenge forcing testimony under oath. Defamation is hard to prove, especially for public figures, but the filing lays out a timeline. It presents a pattern of behavior lawyers will argue was malicious and damaging. A $1 million federal lawsuit is profoundly serious. It brings depositions, discovery. It's the kind of thing that would make anyone consider hitting the pause button. If the Connecticut lawsuit is the main event, then a high-profile custody case out of Utah serves as a stunning undercard, showcasing a similar pattern of alleged disregard for facts. This case involved a series of viral TikTok videos where a minor child made accusations against her father. Swithin seized upon this narrative, amplifying the child's claims on her platforms, and presenting the mother as a heroic, protective parent fighting a corrupt system. Her followers rallied, the story spread, and the father was tried and convicted in the court of public opinion, fueled by Swithin's advocacy. It was a perfect story for her brand: a brave child, a victimized mother, an allegedly abusive father. There was just one problem: the actual court disagreed vehemently. After a thorough investigation, the court issued a massive 124-page report. You could print it out and use it as a doorstop. Its findings were a complete and total refutation of the narrative Swithin had been pushing. The report determined multiple investigations found no evidence to support the abuse claims against the father, Brent. Instead, the court found the mother, Jessica, to be non-supportive and manipulative, and that her actions jeopardized the children's welfare. After the court's findings, Tina Swithin fell silent. At this point, you might be asking yourself, who exactly is Tina Swithin to be making these life-altering judgments about families? Is she a licensed psychologist, a seasoned family law attorney, a certified forensic investigator? The answer, according to critics like licensed therapist Linda Gottlieb, is a resounding no. Swithin is not a licensed clinician. She has no formal, accredited training in diagnosing complex issues like parental alienation, no record of passing professional challenges, like a Dober hearing, to validate expertise. This is a critically important point. When you are dealing with families in crisis, expertise matters. It's impossible to ignore that Tina Swithin's advocacy is also a business, a well-oiled machine designed to monetize family conflict. The Lemonade Club, about $25 a month. Coaching services, workshops, monetized websites, platforms designed to draw traffic, clicks, engagement, customers. Certainty sells, outrage sells. It raises a conflict of interest. Escalation can be profitable. Beyond legal filings and financial incentives lies the most tragic part, the impact on children. Real children are being placed at the center of public, often vicious adult conflicts. The Utah case is a horrifying example. The court noted Swithin broadcast a minor child's private videos to a large audience. That child's face, story, and trauma were transformed into content. It weaponizes them in their parents' disputes. It teaches them their stories have value only when sensational and public. It robs them of a private childhood and forces an adult role they cannot comprehend. The long-term psychological damage can be incalculable. So why did Tina Swithin really pause her public work? While harassment was stated, public records suggest a more compelling explanation. She was cornered. $1 million federal defamation lawsuit and damning court findings. A rising chorus of criticism. The pause wasn't just a break. It was a strategic retreat. Demand evidence. Demand accountability. Accountability is coming from the slow, fact-based process of the law. Before amplifying a story, ask, who is telling this? What are their qualifications? Do they profit? And what do the official records say?